Special United Nations Ambassador GERARD NSENGIYUMVA. I'm here to share with you the next part 3 of United Nations human rights mechanisms. There are regional human rights systems, regional human rights instruments and mechanisms have played an increasingly important role in the promotion and protection of human rights. Regional treaties, conventions, and declarations, for instance, regional instruments, help to contextualize international human rights norms and standards to the particular human rights concerns of the region. Regional human rights mechanisms such as commissions, special rapporteur, and courts then support the implementation of the regional instruments on the ground. Regional human rights systems help to promote and protect human rights by assisting national governments with the implementation of their international human rights obligations, providing people with a more accessible mechanism for the protection of their human rights once national remedies have been exhausted, where individuals' complaint procedures are in place, helping to raise people's awareness of their human rights, placing them in a more localized context and reflecting their particular human rights concerns, providing regional input, to the development of international human rights standards and the improvement of international human rights mechanisms, helping national governments to better address regional human rights concerns that cross national borders, for instance, migration, transnational crime, and environmental disasters. The three most developed and extensive regional human rights systems are to be found in Africa, in Americas, and in Europe. Americas. The Organization of American States is the intergovernmental context within which regional human rights instruments and mechanisms for the region are found. The two main human rights instruments in the region are the 1948 American Declaration on the Rights and Duties of Man, the human rights backbone of the Charter of the Organization of American States, and the 1969 American Convention on Human Rights, which is legally binding on the 23 states that ratified it by the time I ran the discourse. So, instrument, Charter of the Organization of American States and the Declaration on the Rights and Duties of Man. A specific corresponding mechanism is the Inter-American Commission on human rights, including its thematic rapporteur. Then another instrument is American Convention on Human Rights. Its specific mechanism is Inter-American Court of Human Rights. You can get more information on www.oas.org. In Europe, regional arrangements for the protection of human rights in Europe are embedded in three regional intergovernmental organizations: the European Union, EU, the Council of Europe, COE, which comprises of 47 countries by the time I ran this course in Europe, beyond the EU member states, and the Organization for Security and Cooperation in Europe, OSCE. Human rights mechanisms such as the European Court of Human Rights and charter-based mechanisms such as the European Commission against Racism and Intolerance, established by the resolution of the Council of Europe. Treaty-based mechanisms. Treaty-based mechanisms, there are instruments, as I have said, for instance, the European Convention on Human Rights European Convention on Human Rights, which is an instrument, European Convention for the Prevention of Torture and Inhuman and Degrading Treatment or Punishment, that is another instrument. The first European Convention on Human Rights, its specific mechanism is European Court of Human Rights, while the European Convention for the Prevention of Torture and Inhuman Degrading Treatment or Punishment has a specific mechanism of European Committee for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment. There are also charter-based mechanisms. On the side of Council of Europe, there is the European Commission Against Racism and Intolerance Commissioner for Human Rights. On the Organization for Security and Cooperation in Europe, OSCE, there is an Office for Democratic Institutions and Human Rights, while in the EU, European Union, there is a Court of Justice of the EU Charter of the Fundamental Rights. You can get more details on www.echr.coe.int, as well as on the website of curia.europa.eu. In the Middle East, in the Arab world, the Council of the League of Arab States adopted the Arab Charter on Human Rights in 1994, then revised it in 2004. The Charter also provides for the election of a 7-person committee of experts on human rights for consideration to consider state reports. In Africa, all African states are members of the African Union and its main human rights instrument, the African Charter on Human Rights and People's Rights. Instrument, African Charter on Human and People's Rights. Its specific mechanism is the African Commission on Human and People's Rights, and its special mechanisms, African Court on Human and People's Rights. With the exception of Morocco at the time of drafting, for an updated list of world states that have ratified the African Charter on Human and People's Rights, please see the ratification on the website available on the African Commission on Human and People's Rights, which is with the website www.achpr.org. In Asia and the Pacific, unlike other regions, Asia and the Pacific do not have a legally binding instrument that guarantees human rights. However, in 2009, the Association of Southeast Asian Nations, ASEAN, established the Asian Intergovernmental Commission on Human Rights, AICHR, and on 23rd of October 2009, a non-binding human rights declaration was adopted by Asian leaders. For more, you can get details on www.asean.org. There are questions you may ask. Is there a regional human rights instrument which has been ratified by your country of operation? If yes, what mechanisms are there to oversee the state's implementation of the instrument? Then there is national human rights institutions. National human rights institutions, such as national human rights commissions, play a crucial role in promoting and monitoring the effective implementation of international human rights standards at the national level in accordance with the 1991 Paris Principles, national human rights institutions are intended to be state bodies with no constitutional and legislative mandate to protect and promote human rights. As such, national human rights institutions are state protected, state protect and promote human rights. They have the mandate to protect and promote human rights. As such, national human rights are state-funded bodies, although they often benefit from the donor contributions of other states and organizations. Even though they are state bodies, national human rights institutions must operate and function independently from government. The number of national human rights institutions has grown steadily since the General Assembly of the UN first invited the states to establish these institutions in 1979. Resolution A/RES/34/49. This growth has been encouraged by OHCR, the Commission for Human Rights of the UN, which has been providing advisory and support services to around the world. There were over 100 national human rights institutions operating around the world, of which around 70 have been assessed per year by review as compliant with the Paris Principles and are part of the Global Alliance of National Human Rights Institutions. It is important to note that not all national human rights institutions are compliant with the Paris Principles. In certain contexts, this may call for greater caution in considering how and when to engage with them. UNHCR and the national human rights institutions. Traditionally, national human rights institutions have responded to complaints in the human rights and development spheres only. However, there have been a number of good practices in this field. With the support of UNHCR and other organizations, national human rights institutions have started to assume a more operational role in the protection of displaced and stateless people. For more information on how UNHCR engages with national human rights institutions, you can see guidance on UNHCR's engagement with the national human rights institutions of the year 2020. You can also see the UNHCR engagement with the national human rights institutions for international displaced people protection of 2016. Since 1998, UNHCR has been supporting the Colombia Defensoria del Pueblo, for instance. Resources from HCR are many, and we have some points to consider. One, human rights mechanisms can have a wide variety of structures and functions and may exist at the global, regional, and national levels. Two, at the global and regional levels, the mechanisms can generally be divided into charter-based and treaty-based bodies. Three, charter-based bodies derive their establishment from provisions contained in the charter that founds an organization. Treaty-based mechanisms are linked to specific human rights instruments and oversee the implementation of the obligations contained in that specific instruments. Point 5, at the national level, national human rights institutions may be key partners and may provide effective mechanisms for protecting displaced and stateless people. 6, the diverse range of human rights mechanisms provides a variety of opportunities and tools which UNHCR and other stakeholders can strategically leverage to promote respect for the rights of displaced and stateless people. Then, when planning an engagement with the UNHCR mechanism, ensuring full respect for the rights of displaced and stateless people in accordance with the letter and spirit of human rights law. The humanitarian law and refugee law is at the core of UNHCR's protection and solutions mandate. Strategic use of the international human rights system is of particular importance for the protection of displaced and stateless people for several reasons. One, international treaties and international human rights is broader other persons other than refugees and stateless also fall under this framework. International human rights law sets broader standards than those in 1951 Refugee Convention and Statelessness Conventions. Human rights instruments may be among the only protection tools UNHCR and other stakeholders can rely on in countries that are not state parties to the Refugees Convention, regional and or statelessness conventions. And the UNHCR system establishes a variety of supervisory mechanisms, including but not limited to individual complaint procedures and state reporting procedures. Effective engagement with the UNHCR mechanism generally involves 1. Human rights related analysis as part of protection analysis. 2. Identifying protection challenges which can be addressed under international human rights law. 3. Identifying available human rights mechanisms and needs of engagement. 4. Deciding on approach and identifying key partners and tools for engagement. 5. Engaging with the mechanism or mechanisms. 6. Undertaking activities to promote implementation of the outcomes of the mechanisms. 7. Monitoring and reporting on human rights engagement and the impact. It is recommended that in the protection planning exercises or non- and ad hoc basis, upon identification of new protection risks, protection staff assess if the national, regional, and international human rights instruments that may be relevant are applicable to addressing each identified protection challenge. Identifying relevant human rights mechanisms and the means of engagement available to address is of important point. We are going to keep in mind that there are a range of UNHCR mechanisms and several ways in which UNHCR and other stakeholders can engage with them, each with their own advantages and disadvantages. Once human rights violations or protection challenges have been identified, it is useful to carefully consider which UNHCR mechanism would be relevant to address the particular protection challenges. What are the means through which UNHCR or other stakeholders can engage with the relevant mechanisms? What are the outcomes which could result from engaging with the mechanism through each of these means? The 3 UN mechanisms with which UNHCR most frequently engages are treaty bodies, the Human Rights Council's special procedures, and the Human Rights Council Universal Periodic Review process. The universal periodic review process is the most common channel for UNHCR's engagement with the UPR process, has been in preparation of public country-specific submissions on states which are reviewed by the mechanism. UNHCR may also be engaged in a contribution to UN country team reports, civil society reports, or even working with the governments as they prepare their national reporting. Treaty bodies. The most common channels for UNHCR engagement with the treaty bodies are the contribution of confidential information in relation to the periodic reviews of state parties, using the individual complaint procedures to seek protection for displaced and stateless people, contributing information to the development of new general comments or general recommendations. Engagement with the mechanisms can be planned in the immediate, in mid, or long term, or any combination thereof, depending on the nature of the protection challenges and the particular circumstances, needs, and capacity of the operation. Special procedures. The most contributing to annual reports either thematic or country specific, depending on the mandate, supporting and or contributing to country visits and subsequent visit reports, engaging with the individual communications procedures in relation to displaced and stateless people. So those are the issues, and we have to note that refoulement exhausted domestic remedies and national mechanism to avoid distortion. The state has not ratified any international human rights treaties. Looking at the options provided by the human rights mechanisms, the operation could consider engaging with the following mechanisms in the scenario of refoulement. 1. The individual complaints at the treaty bodies and the individual communications of the special procedures. 2. Reporting to the UPR in the course of periodic review and reporting, engaging with the country visits of the specific procedures. 3. Individual communications of the special procedures and any regional complaints mechanisms applicable to the states. So those are the main points that we have to take in consideration at this moment, and thank you very much for watching.